I'm Director of Gift Planning at Bowdoin. Since its founding, alumni, parents, and friends of the college have helped secure its future by including Bowdoin in their philanthropic plans. My office works with those who are interested in supporting the college through estate plans, such as a bequest or by establishing a life income gift, among other arrangements. A study by Caring.com reports that the number of American adults who have done some initial estate planning, such as an advance directive, is 32%. Planning for the end of one's life can be daunting. My office is committed to developing resources to help people bridge the divide between knowing they need a comprehensive estate plan and taking steps to put one in place, whether Bowdoin is included in it or not. We asked Drummond Woodsum, Bowdoin's legal counsel, if they would create an estate planning presentation as a new resource for the college's alumni, parents, and friends. We are delighted that Jessica Sherb, a member of the firm's trust and estate planning practice, agreed to assist us in this endeavor. Jessica is a graduate of the University of Pennsylvania and the University of Maine School of Law, magna cum laude. She is admitted to practice in Maine and New Hampshire. Jessica has written a number of articles about estate planning and has been recognized by New England super lawyers as a rising star in Maine. Jessica has designed her presentation to address the topic she typically covers in an initial meeting with a new client interested in developing an estate plan. After her presentation, she will respond to questions that we have prepared. Jessica, thank you for being with us today.
Thank you very much, Nancy. So over the next half hour or so, I'm going to cover most of the topics that come up in my meetings with estate planning clients. That includes giving you a general overview of what an estate plan is, talking a little bit about the difference between wills and trusts, talking to you a little bit about the ancillary documents in addition to a will and trust that go into a comprehensive estate plan. We'll also talk a little bit about what happens without an estate plan, either upon your disability or upon your death. We'll also talk about some general tax issues that I always want to keep in mind when I'm working with clients. Then to wrap things up, I'll talk a bit about how people can overcome the biggest hurdles to doing their estate planning and how to get started once you've made the decision to move forward. So first, what is estate planning? Most people who call me for their estate planning start the conversation by saying, I need a will, or we need wills. The focus is on that single document. But really, the will is just a small piece of the estate planning puzzle. It's so much more than that. In general, an estate plan allows you to designate who will receive your assets following your death. But estate planning isn't just death planning. It's also life planning, such as how do you or should you own your assets? Should you own them jointly, individually, or through a trust? And it's also disability planning too. It can name a guardian if you have minor children. It can make provision for family members who have special needs. An estate plan can also minimize taxes, both from the income tax perspective and the estate tax perspective. And it can also preserve your legacy. So again, when people think about estate planning, they're usually thinking about that almighty will. But really, there are two main types of estate plans. There's what I call a will-based estate plan and a trust-based estate plan. Both of those documents can get you to the same place. There's really no creditor protection benefit or tax protection benefit that one has over the other. So what's the main difference? The difference is really what happens during your lifetime. Trusts are created and funded during your lifetime. You sign the trust agreement, you transfer property to that trust during your lifetime. Wills, on the other hand, do nothing until the time of your death. You sign it, you tuck it away, you think about updating it as things change during your life, but nothing actually happens under your will until your death. One of the threshold questions I need to answer in order to do appropriate planning for my clients is whether they should have a will-based plan or a trust-based plan. Sometimes that's not even on the client's radar. They come in thinking will, and it's something that I'll bring up on my own if I think it would be useful to my clients. On the other hand, some people come in to see me knowing a little bit about trust-based plans and ask, my friend, my neighbor, my cousin's ex-mother-in-law's nephew has a trust. I want one. Do I need one? And my response is to say, well, let's talk about the differences and we'll talk about the pros and cons and we'll decide together what makes the most sense for you. So what is a will? A will is a document that controls the disposition of your assets upon your death. It also names a personal representative or executor to do what your will says. It can also name a guardian for any minor children that you might have. What are the benefits to using a will as your primary estate planning document? Like I mentioned, there's no action needed during your lifetime because it operates only at your death. A will can include all the intricacies of a trust-based plan. So having complicated assets or a complicated plan or complicated beneficiaries doesn't necessarily mean that you need a trust. You can do the same things in a will. So what are the cons to having a will as your primary document? Well, it has to go through probate. And probate is a court proceeding, which requires the person you name as your personal representative or executor to file a petition for probate in the appropriate probate court. That court then issues authority to the personal representative or executor to act under your will and manage and distribute your assets according to the terms of your will. Because it's a court process, it can take some time. And in some states, the assets that are going through probate are essentially locked up for a certain amount of time until a creditor's claim period passes, for example, or until the court authorizes distributions to beneficiaries. Most states these days, however, have very streamlined probate processes, and the probate laws aren't as draconian as they used to be. That's certainly not the case for every state, so it's important to talk with your advisor about what the probate process entails in your particular state. Again, because it's a probate proceeding, it costs money. There's a filing fee that's imposed by the probate court, and if you engage a lawyer to help you through the process, you're going to have to pay legal fees in addition. But there's no requirement that there be an attorney help you, and most people can do this independently. The probate process in your will only disposes of what are called probate assets. And this is important because there are a lot of assets that are not probate assets. I'll talk a little bit about that later on as well. But it's important to keep in mind that your will does not control all of your assets. Finally, one negative aspect to using a will as your primary estate planning document is that your will becomes public record at the time of your death when your personal representative files it in the court. That said, I don't think a lot of people know that it's public record. I don't think many people know that you can go into the probate court or perhaps look online and get a copy of a will that's been filed in the probate court. In addition to that, most of the time your will doesn't have a lot of personal information in it. It's not going to list out all of your assets, what their values are, or things like that. Most of the time your will is going to have just sort of general catch-all language. For example, mine might say that at the time of my death, everything I own passes to my husband or to a trust for my husband's benefit. And if he isn't living, everything that I own passes to my children or to a trust or trusts for their benefit. It's not going to lay out the items that I own and again, what they're worth and who gets what exactly. So the privacy component for the wills, the fact that they're a public record, isn't quite as strong as some people might think that it is. So what is a revocable living trust then? Some people refer to these as living trusts or revocable trusts or rev trusts. They're all the same thing. So unlike a will that relies upon the probate process to distribute your assets, assets that are held in a revocable living trust are not subject to the probate process. So having a living trust can allow your assets to avoid having to go through the probate process at the time of your death. And this can be important, especially if you own property in multiple states. If you die a resident of state A, but you've got property in states B and state C, not only do your assets have to go through probate in state A, where you are a resident, but you will also have to go through what's called an ancillary probate process in states B and state C to distribute the property located in those states. If you have instead a revocable trust that owns those assets, they are no longer subject to probate in any of those states. Unlike a will, a revocable trust is a private document. So the will gets filed in the probate court. Your trust does not. Your living trust doesn't get filed with a probate court or with registries of deeds or anywhere else public. So there is certainly a privacy factor in the living trust. There are also a couple of cons to using a living trust as your primary estate planning document. First, it's only as good as what you put in it. So if your goal is to avoid the probate process following your death, but you don't retitle your assets to that trust during your lifetime, it's not going to do you a lot of good, because if you own assets still in your individual name, they become subject to probate. So there's a bit of an administrative burden initially when you're having to retitle your assets, such as your real estate, your vehicle, your bank or brokerage accounts, to your trust. In addition, it has to be kept up during your lifetime. I mentioned it's only as good as what you put in it. So if you are buying assets after you establish your trust, you need to take title to them or retitle them to your trust. You also will still need a will, even if you have a living trust as your primary document, in order to catch any of those assets that might not be titled to your trust during your lifetime. That type of will is what I refer to as a pour over will, because it essentially picks up any assets that you still own individually and pours them into your trust. So although your trust will still control the distribution of the assets, you might have to rely on the probate process and your will to get everything there. So which is the best for you? It really depends. What are your goals? Are your primary goals avoiding the probate process following your death? Is a primary goal a privacy factor? Where do you have property? Is it located in multiple states? If so, maybe it makes sense to use the revocable trust in order to avoid having to go through the probate process in other states. It really depends, again, on what the probate process is like in your state. It's not the same across every state. Some states have very easy processes, some do not. Also, are you going to keep up with the trust during your lifetime? Some clients who come in to see me thinking that they're going to go with a revocable living trust, at the end of the conversation say, you know what, I know myself, I know I'm not going to keep up with that during my lifetime, let's just stick with a will. So in addition to the will or the revocable living trust, another important document that's part of a comprehensive estate plan is a financial power of attorney. What this document does is it designates and authorizes an agent, and hopefully a backup, and perhaps even a backup to your backup agent, to make financial decisions for you and to deal with your assets during your lifetime if you're not able to do so yourself. There are really two different types of financial powers of attorney. One is a general power of attorney, and that's typically what I use for my estate planning clients. It authorizes the agents that are named in it to essentially do everything that you could do with your own property. There's also a limited power of attorney, and that document is exactly what it sounds like. It's authorizing an agent and maybe a backup agent to act for you, but only in specific limited situations. And the best example of that is usually a real estate transaction. You're set to close on the purchase or sale of some property, but you're not able to attend the closing for whatever reason. You might sign a limited power of attorney authorizing an agent to attend for you and sign for you solely for that one transaction. Why do you need to have a financial power of attorney? Certainly for disability planning purposes. There comes a time in many people's lives where they're not able to act with respect to their assets. And having a financial power of attorney in place that designates somebody to do that for you makes the process so much more simple. It's also important for convenience planning purposes. You can make your financial power of attorney effective immediately as opposed to effective only upon your disability. And that would allow somebody to act for you if you're simply not able to do something, but you're not incapacitated or disabled. The next document that I talk to clients about is a medical power of attorney. It's similar to the financial power of attorney in that it designates and authorizes an agent, and again, hopefully a backup and maybe another backup, but to make medical decisions for you during your lifetime if you're not able to do so yourself. The medical power of attorney is similar to the financial power of attorney, but they're distinct documents. Your medical power of attorney only authorizes someone to make medical decisions for you, and your financial power of attorney only authorizes someone to make financial decisions for you. Now, the medical power of attorney or healthcare directive or healthcare proxy also typically includes a living will component, and that may be a separate document that goes along with it, or it may be part of the healthcare power of attorney itself, and that depends on which state you're living in. But the living will addresses the end of life decision aspect. You can give your agent some direction about what your wishes are in certain circumstances. For instance, whether you want life-sustaining treatment provided if you are unconscious and your healthcare providers say that you're not likely to regain consciousness. You can also give your agent and your healthcare providers some instruction about what your wishes are for organ or tissue donation in this document. The healthcare directive is obviously important for disability planning purposes. Again, many of us will need to rely on these documents at some point during our lifetime, whether because of an accident or because of age-related dementia or incapacity. And we rarely have advance notice when that's happening. So having a document in place ahead of time is so important. I mentioned back when we were talking about wills that wills only control your probate assets. And I said that many assets aren't actually probate assets. So your beneficiary designations control a number of assets that don't pass through your will or through your trust. And those assets include life insurance or retirement plans. Those assets have beneficiary designation forms that are attached to them. Also, assets that you own jointly with another person, you can consider as having a sort of beneficiary designation attached automatically. If you own real estate or a bank account with another person jointly, that asset is going to pass completely to the survivor upon your death. Your will or your trust doesn't govern where it's going to go. Also, transfer on death or pay on death, so TOD or POD assets such as brokerage or bank accounts will pass according to the designation that you've made. Some states also allow real estate to transfer upon your death automatically by execution and recording of a transfer on death deed. Similarly, some states will allow securities to pass automatically if they've been designated to be transfer on death securities under your state law. Why does it matter? Again, your will or your trust doesn't control these assets. And for many people, these beneficiary designation controlled assets make up a significant portion of their assets. When you think about the value of your life insurance policies and the value of your retirement account, we want to make sure that those assets pass in a coordinated manner with your will or your trust. It's also important because a lot of people started their jobs, started their careers, maybe before they got married or before they had kids, or maybe they've gotten divorced since they updated their beneficiary designations last. You want to make sure that they're up to date and again, that they coordinate with your overall plan because they are going to pass outside of the rest of your document. There are also a few other documents that I will either prepare for clients or I suggest that they keep with their other estate planning documents. First of all, information about online accounts. Everything is online these days. Social media is what keeps us in touch with friends and family. We're paying bills and handling transactions online. It's important to think about how your digital presence is going to be dealt with if you were to become disabled or upon your death. Is anyone authorized to access those accounts? In general, no, unless it's something that you have already provided access to another person to, or if you've signed an authorization and consent for release of electronically stored information. And that document is typically one that I will prepare for clients, and it authorizes their agents, so their agents under a financial power of attorney, their personal representative, or their trustee to access their online accounts. I also suggest that we'll keep a list of logins that include usernames and passwords, and you can keep that somewhere secure. You can provide it perhaps to your attorney's office. Some offices will allow clients to store that information with them, as long as the client also provides triggering event information. So they need to provide them with information about when it's okay to release those usernames and passwords to somebody seeking access to them. I also suggest that people keep information about memorial instructions with their estate planning documents. And this can be information about prepaid funeral or burial services, information about what you would like or what you wouldn't like at a funeral or celebration of life, what you would like or what you wouldn't like for a burial as well. And you can also provide just an overall roadmap for your agents, your administrators, your loved ones. For example, if you have a list of tangible items that you want to designate to particular people, or a general list of what you have and where it is located. It's just a good starting point for anybody who has to step in and manage your affairs for you, whether again, because you're temporarily incapacitated or because you've passed away. So now I've talked about all the documents that I think go into a comprehensive estate plan. So let's talk a little bit now about what happens if you don't have a plan. If you don't have a will, don't worry, your state of residency is going to provide one for you. Every state has a set of intestacy statutes. When you die without a will, you are said to have died intestate. So each state provides these statutes that say what happens to your property if you die without a will. But rarely, if ever, do they provide for the distribution of your assets in the way that you would if you had chosen to do so yourself by signing a will or a trust in advance. In most states, there's some provision made for the spouse, if any, and for children. Sometimes everything goes to the spouse. Sometimes the spouse is going to share assets with the children. Sometimes the spouse is going to share assets with the parents. Rarely, if ever, do the intestacy statutes, though, provide for what you really want or what you need. For example, if you have minor children, the intestacy statutes don't create trusts for the children to certain ages. They also don't obviously address any beneficiaries who might have maturity issues. Maybe you have adult children, but they're not financially responsible. The intestacy statutes don't care. What if your spouse or your children have creditor issues or special needs? None of those factors are taken into consideration in the intestacy statutes. In addition, even though the intestacy statutes might provide automatic protection for some people, they're not going to provide for everyone who might be on your personal list. So other relatives, loved ones, or nonprofit organizations that you've supported, none of those will be considered in the intestacy statutes. If you don't have a financial power of attorney, similar to the intestacy laws, the state is going to provide you with something that gets you close. But a conservatorship is a court proceeding. So again, now someone is having to go to the probate court and petition to be appointed as your conservator. Will your conservator be the same person you would have chosen as your agent if you had prepared a financial power of attorney? Maybe, maybe not. So that's a risk that you're taking in relying upon the conservatorship process as opposed to preparing a financial power of attorney yourself in advance. You're also running the risk of the time that it takes to jump through the hoops to establish a conservatorship, where there's a period that no one is authorized to act for you. That becomes even more important, I think, in the context of the medical power of attorney. Similar to the conservatorship, states will provide a process for someone to petition to be appointed a guardian for you, and that person is authorized to make medical decisions for you. The time factor is even more important here. If a medical decision needs to be made for you and nobody has authority, the guardianship does take time, and it's so much better if you have this document prepared in advance, where there's a person that you've selected, you've given that person some guidance in advance. What happens if you have incomplete beneficiary designations? Most life insurance policies or retirement accounts will provide for some default rules. Maybe the life insurance proceeds or the retirement account passes to your estate. Maybe it passes to your spouse outright, as opposed to that trust that you might have created for your spouse in your will or your trust. In addition, having retirement accounts pass to your estate can be a very bad outcome from a tax perspective too. I'll talk about that a little bit later in more detail. In the context of estate planning, I want to keep in mind 3 different taxes because they all have implications both during your lifetime and upon your death. First is the gift tax. So the gift tax in general is only imposed at the federal level. As of now, there's only one state in the United States that imposes a separate state level gift tax. Many people know that some gifts don't count and aren't subject to gift tax. First, some gifts aren't subject at all, ever. And those include gifts between spouses, certain payments that are made for tuition purposes, certain payments that are made for medical expenses, and charitable gifts. Those are not subject to gift tax at all. Second, there's an annual exclusion amount, or an amount that you can give annually to any number of people and have no gift tax implications whatsoever. For 2020, for instance, that amount is $15,000. Third, in addition to those gifts that don't count for gift tax purposes, every individual also has a lifetime exemption amount. In 2020, that amount is about $11.6 million, and that's indexed for inflation up to 2026. And that amount can be used to shield gifts from the federal estate or federal gift tax. This amount is also the estate tax exemption amount, and I'll talk a little bit later about that. But it's important to know that that $11.6 million figure is for lifetime gifts or gifts upon your death. You don't get to use that amount both times. So any amount that you use during your lifetime for gift tax purposes chips away at the amount that you can later leave upon your death. The next tax that I want to keep in mind when I'm talking to clients is the income tax. Now, most people think that income taxes end upon their death, but that's not true. And we need to keep this in mind, in particular, when we're administering estates after someone has passed away. Your personal representative is responsible for filing your final income tax return. So for instance, if you pass away on July 1st, your personal representative needs to file an income tax return for you individually the following April 15th, just like we all do every year for income that we earned in the prior year. In some cases, though, your personal representative actually has to file 2 income tax returns. For example, if you were to pass away on March 15th, before you filed your own return for the previous year, which is due the following month, April 15th, and if you earned income in the year of your death, so from January 1st until your death on March 15th, your personal representative now has to file an income tax return the following year as well, reporting that income that you earned during the year of your death. There are also income tax consequences for your beneficiaries. For example, are you leaving them assets that they will be taxed on or not? And again, I'll talk a bit more about that later. Finally, the last tax that I keep in mind for people is the estate tax, and we'll dive a bit deeper into that on the next slide. There is a federal estate tax that currently, as of 2020, is a flat 40% tax on estates over, again, that roughly $11.6 million figure, but it's indexed for inflation each year up to 2026. The estate tax is imposed on an estate before distribution. So it's based on the overall value of the estate. The estate tax for federal purposes has a portable exemption. So that $11.6 million exemption that we each have is portable between spouses. So if the first spouse to pass away doesn't use their entire exemption amount, maybe they don't use any of it because everything is passing to the spouse in a tax-free manner, the surviving spouse can elect to use the unused portion of their deceased spouse's federal exemption. So doing the current math at the current levels, that's about $23 million a married couple can leave for federal estate tax purposes with no estate tax. Some states also have their own state level estate tax. Currently 12 states plus Washington, D.C. have an estate tax, which again is a tax that's imposed on the overall value of your estate. Those states include Maine, Vermont, Massachusetts, Rhode Island, Connecticut, New York, Maryland, Illinois, Minnesota, Washington, Oregon, and Hawaii. In addition to those 12 states, 6 states have what's referred to as an inheritance tax. Now that tax is remitted by the recipient of the bequest and is based on the amount that's distributed to each individual beneficiary, as opposed to the overall estate. Notice that Maryland is highlighted in red because as of 2020, they have both an estate tax and an inheritance tax. Is the state estate or inheritance tax portable? If it's not portable between spouses, the first spouse to die doesn't use their exemption amount, then it's lost. The surviving spouse doesn't have the option to use it and is limited to his or her own exemption. So how do we plan for all of these taxes? What can we do during our lifetimes? If we're lucky enough to have a taxable estate, there are several ways that we can reduce our estates during our lifetimes, such as making gifts. You can use that annual exemption amount. You can maximize your lifetime exemption amount by gifting assets that maybe have a low current value, but that you might expect to appreciate over time. So rather than holding on to that asset and having it appreciate in your hands, and thereby increasing your estate value at the time of your death, maybe you should consider gifting it to your beneficiary during your lifetime so it's appreciating in their hands instead. Charitable gifts are also always a great way to reduce the value of your estate. They don't count toward the annual or lifetime exemption amount. Post-death, there's also some planning that we can do for tax purposes. I mentioned briefly that there's no tax on transfers to a surviving spouse. You can leave an unlimited amount between spouses and there's no estate tax. So when we're talking about tax planning, it's really focused on minimizing taxes at the second death if we're talking about a couple. One technique we can use for post-death tax planning is disclaimers. And a disclaimer allows your beneficiary or beneficiaries to, at the time of your death, essentially say, I don't want to accept that. Something was left to me under a will or under a trust or under a beneficiary designation. I don't want it. And by doing that, by exercising a proper disclaimer, and there are certain requirements that are imposed by state law and the IRS that go into what makes a valid disclaimer, if it's exercised properly, the result of that is that that asset that's disclaimed passes to the next person in line. A lot of times we use that type of planning with surviving spouses. So perhaps a surviving spouse disclaims assets into a trust for that spouse's benefit in order to use some tax planning vehicles. Or maybe the surviving spouse knows that he or she isn't going to need that asset during their lifetime and wants to instead have it automatically passed to the children. The surviving spouse can do that by exercising a proper disclaimer. Again, charitable giving is an excellent way to minimize taxes. It's a great vehicle. Charitable bequests result in a charitable deduction on an estate tax return. I want to talk a little bit now about income tax planning. I mentioned earlier that some assets are subject to tax in your beneficiary's hands, but some aren't. Life insurance, for example, is not taxable to your beneficiaries, so it's a great asset to leave to individual beneficiaries. Traditional retirement accounts, on the other hand, are going to be subject to income tax in your beneficiary's hands. I want to talk now a little bit about the SECURE Act and the pretty significant impact that it had on planning for retirement accounts, and why it can be helpful to everybody to be just at least a little bit familiar with it in the context of your estate planning. The SECURE Act went into effect on January 1st, 2020, and a lot of people refer to it as the death of the stretch. Some of you likely know that if you died before 2020, the beneficiary of your retirement account could stretch payments from that account over their own life expectancy, which was great because it would allow the funds to continue to grow on a tax-deferred basis during their lifetime. And they were only paying income taxes as they took those distributions out from the retirement account. After the SECURE Act, with some exceptions, that's no longer the case. And accounts in general need to be paid out within 10 years of your death, which is going to accelerate the taxes that are due on them. So that said, again, there are some exceptions. A surviving spouse, for example, is still able to use his or her life expectancy or roll over the retirement account into her own rollover IRA. But the previously favorable tax treatment that existed for retirement accounts, again, with those limited exceptions, is really no longer there. So this changes the analysis involved in choosing the beneficiaries of these assets. For example, while your individual beneficiaries will have to pay taxes on the accounts as they receive those distributions, your charitable beneficiaries do not. Because charitable organizations are tax exempt, they're not paying income taxes regardless of how quickly they have to withdraw funds from the retirement account. So the downside of the SECURE Act hurting individual beneficiaries actually makes retirement accounts even more attractive charitable giving vehicles than they already were if you're at all charitably inclined. You really get a lot more bang for your buck if you're using retirement accounts for charitable giving. So you might be thinking, well, can I just name my estate? Or can I rely on the default rules of my retirement account? What's the harm in doing that? It's generally not a good idea. So I mentioned under the SECURE Act that it dropped the stretch from the beneficiary's life expectancy to a 10-year payout. It's even worse if you name your estate or if you don't complete a beneficiary designation, and the default is that it passes to your estate, because now the required payout is 5 years, which is going to accelerate the taxes due on that account even faster than it is generally under the SECURE Act. There are also other tax implications based upon the asset that we're talking about. Some of you might know that upon your death, any assets that you own receive what's called a step up in basis. What that means is that whoever receives that asset from you upon your death starts out with the fair market value of that asset at the time of your death, as opposed to taking your own basis, which is basically whatever you paid for it, as their basis. So for example, if you bought a house for $100,000 and it's worth $500,000 at the time of your death, you leave that to your child, who later turns around and sells it when it's worth $500,000, they're not paying any tax on that. There's no gain. They're starting with that $500,000 fair market value as of the time of your death. They sell it for $500,000, there's no gain, no income tax consequences. If, on the other hand, you gift that same asset to your daughter during your lifetime, instead of getting that step up in basis, she instead takes your own basis, which now is that $100,000 that I mentioned earlier. So if she then turns around and sells that house for $500,000, she now has $400,000 worth of gain that she's having to report on her income tax return. So for your estate tax purposes, it might make sense to kick out some of the lower value assets during your lifetime that you expect to appreciate. It may not make sense to do that for gift tax purposes, though. Again, with a gift, your beneficiary is taking your basis. With a bequest upon your death, your beneficiary is taking that stepped up basis. So it's really a balancing act, and we need to talk about goals and priorities when we're deciding who gets what and when they're getting it, whether it's a gift during your lifetime or a transfer upon your death. There are a number of hurdles that people often need to overcome when it comes to doing their estate planning. As Nancy mentioned, it's a very low percentage of people who have actually engaged in their estate planning. A lot of people say, well, I don't know how to pick an agent. I don't know how to pick an executor, a guardian for my children, a trustee for a trust for my spouse or for my kids. It's a very difficult decision to make, especially when I'm forcing people to make decisions about backups for all of those roles as well. You might have one person in mind, but it's a reach to try to come up with a backup person who you think would be just as capable or would make you just as comfortable. But when I'm talking to people, what we're really talking about is a snapshot. If something were to happen to you the day after you sign your documents, who would you want to serve in those roles? I fully expect that those people are going to change over time. So whoever makes sense for you today might not be the person that makes sense 5 or 10 years from now, but you can update those documents as things change. And also keep in mind, if you don't pick people to play in these roles yourself, the court is going to pick someone for you. So as hard as it might be for you to think of someone and pick someone, think about the consequences where the court is doing that for you. A lot of other people will say, I don't want to do my planning because I don't want to think about it. I understand. Nobody wants to think about their own mortality. It makes us feel vulnerable. I get it. But I think it makes more sense to look at it from a different angle. And instead of thinking about your vulnerability, think about the fact that developing an estate plan is actually pretty empowering. It's a way for you to make sure that your voice is heard when you're still living, but unable to speak for yourself because you've become disabled, or also following your death, you're able to leave detailed information about what your wishes are. It's intended to give you peace of mind by protecting yourself during your disability and also protecting your interest and your loved ones. Other people say, my situation is messy, it's complicated, I don't want to have to sit down and deal with it now. The best thing to do is to clean it up, make it less messy. Don't leave it for your family, for your friends, for other loved ones, or for the court to have to figure out when it's too late, when you're not able to do it yourself. I think probably the biggest reason people give for not doing their planning is that they just haven't gotten around to it. They don't have the time. Everyone seems to know that it's important and that it's something that they should do. And I understand everybody is busy, but this is just one of those pesky things that you need to make time for. So what's the best time to engage in your estate planning? Now. Putting it off doesn't make it any easier, and by the time you need it, it's often too late. So how do I get started with my estate planning? Contact an attorney. You want to work with someone who does this regularly. How do you find one if you don't already have a relationship with someone? Ask for recommendations. Ask your family, your friends, your insurance agent, your financial advisor, your gift planner. Any of those people should be able to provide you with one or more names of people that you might want to reach out to. And get on the phone with those people. You don't have to make a decision immediately. Most people will offer to at least have a phone call, if not a sit-down meeting with you for free. If you have contacts in another state, ask them for a recommendation. I would say probably 95% of the time when somebody asks me for a recommendation in another state, I'm able to find someone. We all have networks. I'm asked frequently to make recommendations for attorneys in other states. Sometimes there's somebody that I know that I've worked with before that I can quickly recommend, or sometimes I can reach out to a contact of mine or an online network that I have, even if it's someone that I'm not personally familiar with. Gather information. A lot of times people will have their own forms. Estate planning attorneys will have forms that they will send out to clients in advance. There's a form available at the Bowdoin link in this slideshow where you can gather information about your assets and key players that you want to be involved. That's an important step to engage in before actually sitting down with somebody. And finally, just make the time. Again, I know it's hard. It's something that people don't want to think about. It takes time and effort to go through the process, but I guarantee once you have it done, you will sleep better at night. You will feel better knowing that your affairs are in order. And with that, I will turn it back over to Nancy.
Thank you, Jessica. That was a wonderful presentation, very thorough and comprehensive. We really appreciate your information. So we have a few questions for you. The first one is, can you provide a cost range estimate of what one should expect to pay for putting a comprehensive estate plan in place, say for a typical client, to include, for example, a will or a trust, beneficiary designations, financial power of attorney, healthcare power of attorney?
Yes, so I will give the classic lawyer's response to this, and it depends. Everybody's situation is different. Everybody's situation is unique. It really depends on what's going to be involved in drafting the documents. Is it truly a simple plan that's leaving everything outright to a single individual, or are we crafting trusts for different individuals? But generally, the way most estate planning attorneys operate is by providing a flat fee quote. So at the end of that first meeting, where we know what's going to be involved in the drafting process, we are able to quote a fee of what it's going to cost to do the work that we've discussed. I would say typically the range for most clients is somewhere between $1,500 and $3,000.
Thank you. And how often should someone review their estate plans?
Again, that really depends. It depends on when things change in every individual's life. I don't tell people it's something that they need to update every year or 2 years or 5 years. I do think it's worth taking stock of your plan, at least on an annual basis. Maybe 4 out of 5 times you will say, you know what, I think we're still in good shape. But on that 5th time, you say, you know what, things have changed, our children have grown, the person we want to serve as guardian has changed. And at that point, you should contact your attorney and talk about making some updates.
Great. Do you think that people who take a do-it-yourself approach to the wills realize that they need other elements such as the power of attorney, the advance directives, beneficiary designations, digital presence? And what is the best means of educating people about why they need to take a comprehensive approach?
So I don't think a lot of people do realize all of those documents go into a comprehensive estate plan. I think a lot of people, when they do some amount of planning, they're doing it in sort of a piecemeal approach. Their bank has offered a financial power of attorney. Their healthcare directive, their doctors, healthcare providers have suggested a healthcare directive, but they don't have all of the pieces of the puzzle put together. And that's when I think working again with an experienced attorney who does this regularly, really they put the whole picture into focus.
Thank you. When one names a personal representative, a guardian, an attorney of fact on a POA, or chooses someone to make end-of-life decisions, do they need to secure their consent and discuss and provide a copy of their plans? And how do you let those people know where to find the key documents in the future?
So it really depends on the role that you're asking people to play. So I typically suggest that clients not necessarily ask somebody if they're willing to serve as their personal representative or executor or their agent under a healthcare directive or power of attorney. You want to pick people that you are fairly confident will be willing to serve in those roles, but you don't necessarily need to ask them. They're not signing on to any of these documents. You are the only person signing them. The one time where I do suggest that it might make sense to talk to somebody in advance is when you're naming a guardian for your children. I think it usually makes sense to talk to that person and make sure that they would be willing to take on that role. I don't advise clients to send copies of their documents to any of the role players. And the main reason for that is you're likely going to update these documents at some point in the future. And the last thing you want is to have to go back to all of these people that you've given documents to and either ask for them back because you're updating it or ask them to assure you that they've destroyed these documents. You don't want to have multiple dated versions of financial powers of attorney or healthcare directives floating around. As far as where it's best to keep these documents, I always keep the original wills of my clients because those need to be filed with the probate court. We keep them in our vault where they're secure. And I have clients sign multiple originals of the other documents. So they walk away with an original and I keep an original as well. We scan everything electronically. So we've got electronic copies as well as hard copies in our office. So I don't want clients to tuck their documents away in a safe deposit box or a fireproof safe somewhere in their home. We want them somewhere where whoever might need to access them can find them. So if you have a home office, a bookshelf somewhere, put your documents there where people would likely look if it came time that they needed to have access to them.
Thank you. So we have one last question. In working with people who hold complex and multiple holdings, such as personal property like collectibles or tchotchkes, real estate holdings, different types of bank and brokerage accounts, how do you advise them about providing a roadmap for their personal representative, as the complexity could make the estate settlement difficult, time-consuming, and possibly costly?
Yeah. So first of all, I think it's great to keep a list of information about what your assets are with your other estate planning documents. So again, most people are going to be completing some sort of paperwork before they sit down with their estate planning attorney. Keep that paperwork, a copy of it, with your other estate planning documents. So it will give your agents, your personal representatives, a good idea of what you had at the time. And if you can, update it as things change. You don't have to keep track of dollar amounts, but just giving your agents, your personal representatives, a general idea of what you have can make things so much easier for them. Also, a lot of people are concerned about the burden it places on somebody to have them serve as your personal representative or your agent. And I always like to remind people that even though you are naming someone to serve in those roles, that person isn't on an island by themselves. They're free to talk to other family members or friends of yours who might have an idea of what your wishes were if it's not clearly spelled out. They can also work with their own attorney to help with administration. They can work with an accountant or financial advisor. So try not to be too concerned about what you have and the complexity of it. Just trust that the person that you're naming is responsible enough to get the help that they need if they do need any.
Jessica, thank you so much, and also to your firm, Drummond Woodsum. Your presentation will be a useful and valuable resource for Bowdoin alumni, parents, and friends, and we do so appreciate it.
My pleasure. Thank you.